I'm sorry. I know my son, I make no excuses for, I don't condone any of his behavior throughout juvenile court and now in your court today.
He has no position with regard to, ultimately he feels like the court and relying upon the court and the state to have his best interest at heart as far as what happens here. There is restitution for medical bills that are he is requesting. I believe that number is $11,277.75.
77 or 27?
77.75. Sorry, 277.75.
Anything from probation?
Nothing further than what was discussed in chambers.
Mr. Aldridge?
Several things, Your Honor. First off, the defendant's mother is present. She would like to address the court.
Okay. Come on up.
Ma'am, if you just want to stand on the other side of this table here, in front of this chair. You don't have to speak into the microphone, it's recording you. Move that chair out of the way. If you can just state your name for the court reporter.
Jennifer Buchanan.
What would you like me to know?
I'm sorry. I know my son, I make no excuses for, I don't condone any of his behavior throughout juvenile court and now in your court today. However, I would like you to take into consideration that since this incident happened, he has been compliant with anything that they have asked him to do. He has taken initiative to work with his physician in getting on a good medication regimen to help with his multiple mental health diagnoses. I know when he comes in front of, the investigators, that it is very hard for him to articulate how he feels. He has a very flat affect, which makes him seem, I don't know how to describe it, just makes him seem like he's not, I don't know how to explain it correctly to make you understand, but during his confinement at home, we have had multiple discussions regarding his behavior, his future, the things that he's done, the chances that he's had, etc. And he does not, I can say just from talking to him myself, that he does not want to continue to come in front of the court and continue to, he doesn't want to spend his life in jail. He doesn't want to, he wants to have a normal life. He wants to go to school, get an education, start a career, and that kind of thing. He's gonna, depending on what happens here today, he's going to Warren County Career Center here in a couple of weeks, depending obviously on the outcome today, to talk with several instructors there to determine if there's a program at the Career Center that he could take to have a career, go to school, get educated. He even talked to an Army recruiter to possibly, if depending on, again, the outcome of today, on possible military service at some point, to try to get his life in order. He has never set out to hurt anybody. he knows that what he did is wrong. But he's made changes to abide by the GPS monitoring, the probation, even prior to being charged. You know, he followed like the guidelines that he was supposed to follow. So I would just like you to take all of that into consideration. When you make your decision on whether to, however you decide to, the punitive aspect of this.
Thank you.
From a legal standpoint, this is mitigation, not exoneration. The court hears parental advocacy often, especially when mental health and youth are involved. But compliance after being charged doesn't erase a documented pattern of violence. The judge isn't evaluating intentions or future plans right now. He's assessing risk, credibility, and whether community control has already failed. Sympathy may explain behavior, but it doesn't neutralize public safety concerns or a record this extensive.
Anything else?
We have submitted a couple of letters to the court, including an apology letter to the victim. In addition to that, I would point out that Isaiah, well, it may be somewhat unknown exactly what his mental health issues are. I think he does have some significant mental health issues that have affected not only this incident, but obviously his prior record over in juvenile court. And obviously we're not looking to downplay that at all. He has not been very cooperative with the court system in the past. But I think it's important to note in the year and a half since this incident occurred, he has made some significant changes. He has not been back in court for anything else since that time. He's been compliant with the GPS monitoring. I know the court has concerns about his marijuana use, but he's actively tried to address that. It seems like the levels have been consistently going down, even if it's not completely out of the system at this time. I agree with Mother, what she was trying to say about his affect. I mean, he does come across as kind of nonchalant, not caring about the situation. I don't think that's true. I think he just struggles to express that verbally. And he does come across, in my experience with him, much younger than his age, not as mature as you would expect. And I think that is attributable to his ongoing mental health issues. I think it's a positive that he has removed himself away from Franklin and the kids that he was running with over there. I think that's had a large impact on him staying out of trouble in the past year and a half. So it seems like he's making some good choices here. He's 18 years old. Sorry, Your Honor.
It's all right. Go ahead.
He's 18 years old. And obviously this is his first time here over in common pleas court. I do think that he can benefit from the opportunities and things that this court can provide to get his life on track now, so we don't see him back here again and again and again like he did over in juvenile court. And again, as I discussed in chambers, Your Honor, my concern is sending him to prison at this time. It's not going to be a good outcome for him. So I do request that the court consider placing him on probation. He's going to comply with whatever you tell him to do, and hopefully he can move on from this and make something of himself.
Did he test today?
I didn't get an email, but.
I didn't either.
I believe he did test positive for marijuana this morning, or that's what they told him at least. Again, I don't know what the level was, but.
Well, they wouldn't know the level until they
Yeah.
send it out for confirmation. All right. Anything else?
Nothing else, Your Honor.
Mr. Buchanan, is there anything you'd like to say before I sentence you?
Yes, I would like to say that I am very remorseful for everything that's happened, and I got onto some new medicine to start taking.
For what?
My anger, my ADHD, and just to help stabilize myself.
You don't take medicine for your anger. What's the medication prescribed for? What's the diagnosis that it's prescribed for?
I'm not sure my exact diagnosis, sir.
Yes, ma'am.
At this point, the court isn't evaluating remorse. It's evaluating credibility. The defendant speaks in broad terms: regret, medication, self-improvement, but offers no concrete diagnosis, no documentation, and no medical verification. In a sentencing hearing, that matters. Courts don't sentence based on intentions. They sentence based on records, patterns, and accountability. When a defendant can't clearly articulate the basis for treatment, the judge is left to rely on what is provable, not what is promised. This moment marks a shift from personal explanation to judicial scrutiny.
He is on Prozac. It's an antipsychotic. It helps with. He's also talked to his physician about a mood stabilizer. He has been on these medications off and on for years. He just has really bad side effects to those. They also have talked to him that if this doesn't work, that there are other medications that he can take. He has several diagnoses. He has generalized anxiety disorder, PTSD. He has social pragmatic communication disorder, which is Asperger's, just it's a different name. So he does have several diagnoses that he is medicated for.
According to the court assessment, he has been diagnosed with depression.
Oppositional ADHD and oppositional defiance.
That's not included in the assessment.
We explained all of those to her.
Well, I know you explained it. Was there any documentation provided of any of these diagnoses? Because this assessment was done, I don't have a date on it, but it says he's depressive disorder, attention deficit hyperactivity disorder, cannabis use disorder. That's the extent of the diagnosis.
Juvenile court was provided with his medical records.
Juvenile court provided us with nothing, ma'am. Juvenile court didn't even provide us with any of his infractions that were requested while he was in juvenile detention.
Okay.
We got nothing from juvenile court,
Okay.
although it was requested.
Okay, because she said was going to request that, and that's why I did not provide his, because she said she was going to request that.
All right.
But
Go
he
ahead.
does have several mental health diagnoses, sir.
Just for the record, the Talbot House assessment was conducted on November 14th of 2025. He was diagnosed with major depressive disorder, attention deficit hyperactivity disorder, and cannabis use disorder. The diagnosis that he provided pre-trial was ADHD, oppositional defiance disorder, intermittent explosive disorder, PTSD, and social pragmatic communication disorder. All those diagnoses were self-reported, and we do not have any verifying documents at this time.
All right, go ahead, Mr. Buchanan. What else do you want me to know?
And I'm also looking into furthering my education.
Did you complete your high school education?
Yes, sir, I did.
Okay, go ahead.
And I was looking to go to the Career Center. I've also reached out to other schools. And also, like my mom mentioned, I contacted a Army recruiter. I'd like to go and talk to them and see if maybe I could get into that. And any type of programs or anything that you sentence me to, I'm going to work them. I'm going to do everything as you say. And I just apologize and I'm sorry. And I would ask for another chance, please.
How many chances do we have to give you before you kill somebody? I'm looking at your record, 2018. That means you would have been about what? 14, 13, 12. You're 19 now.
Yes, sir.
7 years ago, you would have been 12 years old. You got your first conviction for assault. Who did you assault when you were 12?
It was a mutual fight at school.
2019, assault. Who did you assault then?
It was also a thing at school.
2021, violation of a court order. 2021, failure to comply with the order of a police officer, felony of the 3rd degree. You know, that's a prison sentence in this court. 2021, violation of a court order. 2021, violation of a court order. 2022, violation of a court order.
Yes,
2023, aggravated menacing. 2024, criminal mischief, criminal damaging. 2024, criminal mischief.
Yes, sir.
You have 3 offenses of violence on your record right now. This is 4. This is your 4th offense of violence.
And I understand that, and I'm looking to better myself. I don't want to live how I did in the past. And I'm sorry. I promise I can do anything, any type of program.
Most people are sorry when they're standing here at this point of the proceedings.
I understand.
I mean, all right, the court's considered the statements made here today, the pre-sentence investigation. The court has reviewed the letters that have been submitted by the defendant, the purposes and the principles of sentencing, the relevant seriousness and recidivism factors. Mr. Buchanan, I have serious concerns for you, and for some reason, and I understand this flat effect that you may present yourself with, but I think this goes much deeper than this. You can't blame violence on just the mental health conditions that you have described here today. That's not the cause of you hurting somebody seriously. I'm sorry?
I said yes, sir.
Okay. I don't need you to respond. I mean, if you have something else to say, I'll give you an opportunity. So you need to say it now, because once I get started, I don't want to be interrupted.
I'm sorry.
Go ahead. Is there something else you want me to know?
No, that's all.
But I do think that our juvenile court system, I know that there are limitations on what they can do, but this is no longer juvenile court, and there are serious consequences. Anytime you make a choice in your life, make a bad choice, there's going to be bad consequences. I don't think that you've taken this as seriously as I would have liked. When you were confronted about the marijuana use, and you and I have had this discussion, your response was, well, juvenile court approved your medical marijuana. I don't know what the benefits of marijuana are. I truly don't. I don't allow marijuana on my docket. I think it's harmful, especially someone of your young age, where your brain is still developing to some extent. It does nothing but harm you. But I don't think that you have taken this as seriously as you want me to believe. And I do find today that you are not amenable to community control. So I am going to order you to serve a prison sentence, a minimum term sentence of 3 years, maximum term sentence of 4.5 years. And the court does find that prison is necessary to fulfill the purposes and principles of sentence, including punishment, deterrence, and protection of the public. You have 0 days jail time credit at this time. There's a restitution owed of $11,277.75 to Joshua Krasik. That is ordered to be paid joint and severally with your co-defendants. You're also subject to a mandatory period of post-release control, which means upon your release from prison, the Adult Parole Authority will supervise you for a minimum term of 18 months up to 3 years. If you violate that supervision, you can be returned to prison for up to 1/2 of this court's original minimum term sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year, or the period that you have left on PRC, whichever is longer. That time would run consecutive to any additional prison time that you get sentenced to. It is possible for you to earn good time credit against your minimum term sentence of 5 to 15%. For good behavior. The court has a right to deny your good time credit. A hearing would be held to make that determination. Regardless of whether you receive good time credit, you will be released when you finish your minimum term unless the Department of Corrections determines that you must remain in prison for bad conduct. The court is not involved in that decision. If you're not released when your minimum term ends, you will serve an additional specified period of time, and given a new release date, you will serve until that date unless you are again denied release. This process would repeat until you are released or you finish your maximum term. Now, before I give you your right of appeal, I want to give you some hope, because it's not my intention to ruin your life. Your decision has caused you a major setback in your life. I will tell you right now that I will consider you for judicial release, and I will release you from prison after a 6-month period in prison. So after 6 months, your attorney will file, you can contact Mr. Aldridge, and he'll file a motion for judicial release. The conditions and what I'm looking at is that you've complied with all the terms and conditions of your confinement, which means you follow the rules. You show me that you can follow the rules. And then after 6 months, if you've done that, I will release you and put you on community control at that time. Do you understand me?
Yes.
I want to give you some hope. I'm not here to ruin your life, but you need to understand that when you hurt somebody as seriously as you did in this case, and you've done it in the past, you've had prior convictions for assault, that there are serious consequences now. You are no longer in juvenile court. Now, you do have a right to appeal the court's decision of your sentence to the 12th District Court of Appeals. If you want to appeal, you must file your notice of appeal within 30 days of today's date. If you can't afford to pay for the transcript or anything necessary for your appeal, that can all be provided to you at no cost. If you cannot afford an attorney, I will appoint one for you at no cost. Mr. Hardman, is there anything else?
No, Your Honor.
Nothing else?
You understand that you have 6 months. Behave yourself, and I will see you back here in 6 months.
All right, sir.
Okay? Right, your bond is revoked. At this time, there's a deputy standing behind you. You're remanded into the custody of the Warren County Sheriffs for transport to the Department of Corrections.
Your Honor, can
Yes,
I
sir.
also say one more thing?
I'm sorry?
Can I say one more thing?
Yes, sir.
I'm not trying to act like I'm not remorseful for this situation. I don't want you to think that I'm trying to say my diagnoses are why I did this. I'm very remorseful, and like I said, I'm more willing to do anything. And with this prison time, I'm going to show you that, sir.
Okay.
And
I look forward to seeing you in 6 months then. Okay?
Sir.
Good luck.
can I please give my mom?
That's up to the deputies at this point.
Does he need?
This sentence marks a clear legal turning point. The court expressly finds the defendant not amenable to community control, a conclusion grounded in documented recidivism factors, a pattern of prior violent conduct, and repeated failures to respond to earlier court interventions. In that context, incarceration is imposed not merely as punishment, but as a necessary measure of deterrence and public protection. But this ruling does not exist in a vacuum. As the sentence is announced, the reality lands, not just on the defendant, but on the mother standing behind him, absorbing the weight of consequences she cannot shield him from anymore. The law moves forward, even when families are left breaking in place. Still, the court leaves a narrow door open. Judicial release after 6 months signals that accountability does not end at sentencing. Rehabilitation remains possible, but only through demonstrated discipline, compliance, and sustained reform. In the end, the message is unmistakable. Compassion exists in this courtroom, but responsibility comes first.